Ladies and gentlemen of the press, Minister of Land Reform and Rural Development, Thoko Didiza. When one reads the words of the founding member and first secretary of the South African Native Congress, Solomon Thabisi Kaplanche, and I quote, "Awakening on Friday morning, June 20, 1913, the South African native found himself not actually a slave, but a pariah in the land of his birth." Close quote. Perhaps due to the passage of time, 108 years to be precise, we do not fully comprehend that with the stroke of a colonial pen, literally overnight, our forebears were stripped not only of their dignity, but of their greatest economic asset, which is the land. State-sponsored dispossession orchestrated the triple challenges of poverty, unemployment, and deep inequality, which are the core of black South Africans' lived experience. The introduction of the Native Land Act of 1913 was not just an act of colonialism, but also an act of systematic economic reconstruction and exclusion. Without the Native Land Act, the migrant labor system would not have been as efficient in the hands of the colonizers. Black South Africans to this day are confronted with the effects of the migrant labor system, which was anchored on land disposition. Therefore, addressing the land question is not only a socio-economic imperative, but it's a matter of restoring the nation's souls. Land justice will restore the soul of the nation. As a commitment to inclusive nation building and constitutionalism, unlike the colonial state, the African National Congress still continues to use laws to address and redress the past imbalances. And the law we are going to introduce today is one of those instruments we want to use to enable society to address the land question. It is against this background that we'll be introducing the Land Court Bill to Parliament. The Land Court Bill is the outcome of the work done by the Interministerial Committee on Land Reform, which is chaired by the Deputy President, Didiza. The IMC has been seized with implementing the recommendations of the Presidential Advisory Panel on Land Reform and Agriculture. The panel proposed the following with regards to the Land Claims Court. The Land Claims Court be converted into a new land court to adjudicate on all land-related matters and not only restitution. This land court must be given additional responsibilities, both judiciary and extra functions, such as conflict resolution and mediation. The court must have a functional approach which is modeled on the negotiations before litigation, on matters such as expropriation without compensations, which is proposed to Parliament in the expropriation bill. The panel recommend that the Land Court include the appointment of a permanent judge, president, and 4 permanent judges. The Land Court should also be required to check that settlement agreements give just and equitable compensation to landowners, in line with Section 25 and the new Expropriation Act, if the bill will end up being, when the bill is finally passed as law. The IMC on land reform has accepted all of these recommendations and has effected them in the Land Court Bill. So what I've just said above is encapsulated in the Land Court Bill that we are going to introduce to Parliament. In addition to the above, the Land Court Bill also introduces the following. It will also have the Land Appeal Court with a jurisdiction equal to the Supreme Court of Appeal as in relation to matters under its jurisdiction and as a court of record, meaning that any appeal from the Land Court will have to be adjudicated by the Land Appeal Court. This is aimed to further develop land jurisprudence in the country. To help the processes of the court, we are currently in the process to transfer the functions of the Land Rights Management Facility in the Department of Agriculture and Land Reform and Rural Development to Legal Aid South Africa. The transfer of the Land Rights Management Facility will ensure that Legal Aid South Africa has both the finances and capacity required to broaden its reach to the indigent, especially those who seek land justice. The process of transfer has begun, as it does not have to wait for the finalization of the bill. We will announce the processes and the procedures as soon as the whole process is finalized. The efficiency of the procedures and arrangement proposed in the bill will assist to develop our land jurisprudence with regards to the land court and with regards to the land question. For instance, the bill still allows for hearsay evidence for most families who have to rely on oral history and the existence of elders with knowledge of the description, location, and extent of land which their descendants previously occupied. It also allows for expert evidence regarding the historical and anthropological facts relevant to any particular land claim. This bill gives effect to the resolutions of the African National Congress 54th National Congress, namely, to ensure our approach to land reform is based on three elements: increased security of tenure, land restitution, and land redistribution. This bill is a concrete intervention to improve the functioning of all three elements of land reform. It creates a policy frame to ensure that land reform is guided by sound legal and economic principles and contribute to the country's investment objectives and job creation initiatives. While the bill on its own may not be a silver bullet which can help us undo the effects of colonialism, it is an important step which can enable land reform, which is inextricably linked to rural development and addressing the socio-economic challenges that plague us as a nation. Thank you.
Thank you very much, Crispin, for inviting me. Minister of Justice and Correctional Services, my colleague, Minister Ronald Lamola, senior members of the Department of Justice and Correctional Services, as well as Agriculture and Land and Rural Development. Welcome, DG of Justice, and I'm happy that you are with us here because you will have to take the mantle in ensuring that the things that Minister as well as the IMC has said on this matter, you will champion. Ladies and gentlemen of the media, some years ago, to be precise, 28 years ago, the Interim Constitution Act 2000 was adopted. Approximately 3 years later, in 1997, the final constitution was adopted by the Constitutional Assembly. This constitution, a clear product of many years of struggle, came against the backdrop of a history of apartheid, a central feature of which was inequality based on race. The inequality resulted in the direct assault of the dignity of black people in particular. It was not only the dignity of black people that suffered, while areas in general were affluent and black ones were in the main impoverished and underdeveloped. Professor Sampieter Blanche correctly observes in his book, I quote, A History of Inequality in South Africa from 1652 to 2002, close quote, that the source of race-based inequalities in South Africa can be viewed from three distinct but related historical events: the loss of political power by indigenous Africans to colonial power, the land dispossession as a result of the loss of political power, and the enslavement and exploitation of black labor. One would appreciate that the effects of these inequalities resulted in the deprivation of land by black people and continued systematic oppression of degradation. This is manifested by the Land Act of 1913, the Urban Areas Act of 1923, and the subsequent amendments of it and the Natives Trust and Land Act of 1936. These are some of the primary laws directed against the African people, which were directed rather against the African people. The direct effects of these acts were that only 8% of South Africa's total land area was set aside as native reserves, whereas the entire land was enjoyed by a few. At its 54th National Conference, the African National Congress, which is the leading party in government, resolved, among others, to pursue with greater determination the program of land reform and rural development as part of the program of radical socio-economic transformation. Minister Lamola has outlined the approach of land reform by the ANC, and I won't dwell into that. It is, however, against that backdrop that government has taken a policy decision to introduce the Land Court Bill to Parliament in order to deal with land-related disputes in the country in an efficient, cost-effective, and just manner. I must say, Minister, that we are very pleased as the Department of Land Reform that finally we are now going to have a court that can actually adjudicate on a number of issues that our ministry and department has had to deal with over many years. Minister Lamola has already explained the rationale and object of the Land Court Bill, which will, among other things, address the systematic challenges faced by the Land Claims Court and ensure the speedy capacitation of the Land Claims Court by ensuring that permanent judges are appointed. This, in my view, will ease the speedy resolution of land-related disputes in the country and the development of land jurisprudence. I must say, Minister, that since 1998, some of the claims that had been lodged with the Land Claims Court have not been able to be resolved, particularly because of these challenges that I've just highlighted and you too have highlighted. And therefore, we are grateful that we have taken this step going forward to make sure that that court can have permanent judiciary. The financial capacitation and expansion of the mandate of the Legal Aid Board to resolve land-related disputes will ensure a speedy resolution of land-related disputes by using the mediation and arbitration approach. Whilst there is a firm intention of redirecting the expenditure of the Land Rights Management Facility from my department to ensure that the Legal Aid Board resolve land-related matters speedily, we will ensure that working together with the Department of Justice and the Legal Aid Board, we also continue our engagement with Treasury, as we know that matters of land continue to bedevil our society, and therefore we will require enough capacity to be able to deal with this. I have no doubt that the introduction of the Land Court Bill will promote access to land on an equitable basis and contribute to a speedy resolution of land-related matters and contribute to nation building and restoration of the dignity of our people. I thank you.